We continue now our conversation with the Chairperson of the General Counsel of the Bar, Advocate Craig Watt-Pringle. Advocate, thank you very much for your time and for waiting for us as we took that NPA briefing. Before that break, you were explaining the reasons why the Deputy Chief Justice cannot really be fingered in this particular instance, and you were describing the circumstances that led to that statement by Advocate Mpofu. Yes.
Well, perhaps what I should first of all explain is what court etiquette demands if an objection is made. So usually when one advocate is putting a question to his or her witness and the opposing counsel believes that the question is not permissible, then opposing counsel can stand up and raise an objection. The convention then is that counsel who was speaking will stand down and allow the objection to be made. And it seems to me that was the principle that Mr. Mpofu was asserting. However, as I mentioned earlier, on viewing the footage of the whole incident, what was in fact in play at the time was not Ms. LaRue putting a question, but Ms. LaRue engaging in debate with the Deputy Chief Justice as to whether the question that she had started to put was permissible or not. So that debate was already ongoing. That's the first point. The second point is that even if the convention is that when there's an objection, counsel against whom the objection is made should stand down and allow the objection to be made, it's always open to a judge or a presiding officer, in this case the chair of the inquiry, to direct how the matter must be dealt with. Justice Zondo was more than within his rights to say, I want to hear out Ms. LaRue because I don't yet know what the full extent of the question is, and then if there's still an objection, I will hear Mr. Mpofu. Mr. Mpofu was not prepared to stand down. Mr. Mpofu, in fact, interrupted the judge himself, at least on 4 occasions that I noticed. And also, as I mentioned earlier, there are ways and ways of asserting your position in court. Counsel are not required to be shrinking violets in asserting the rights of their clients to be properly heard or to be heard themselves in court. But telling colleagues and witnesses to shut up is beyond the pale, and I don't think that Mr. Mpofu can really suggest otherwise.
In conclusion, this afternoon, you have said that a charge or complaint has been laid against Advocate Dali Mpofu. Should he be found of unprofessional behavior, what would be the repercussions of that?
Well, the incident itself is both, it suggests a breach of rules of decorum that counsel are required to maintain in court. But there's another aspect to this, and that is the contemptuous conduct towards the chair of the inquiry, which is perhaps a more serious matter. And there is a further matter of a tweet that Mr. Mpofu issued in response to Justice Zondo's rebuke, which came a day later. And that appears to me to be something that the Johannesburg Bar Council or its professional committee should investigate, because far from showing any contrition, Mr. Mpofu is standing his ground and not accepting the rebuke from the Deputy Chief Justice. So that could result in a more serious sanction. I don't want to anticipate what that sanction might be.
And we certainly will be looking out to see how this particular incident unfolds. Thank you very much for your time and your insight. That's Advocate Craig Watt-Pringle there. He is the Chairperson of the General Counsel of the Bar. Now,